Item 501.
Yes. 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 Because you are not. So the difference.
Singhvi, you are known to keep your word.
Well, I'll probably overkeep the word, please. Within 25 minutes, half an hour. I'll be very pointed.
This
Only-
is only 1 second.
The residual parts.
So we take your written submissions that you have, that you were reading earlier.
That's right, that's right.
There's only short portion which was left back.
Yes, I'll be reading that part and just oralizing the beginning, one set of points, just to, no repetition, and it won't require.
What was the number of that?
Well, as your lordship would be starting.
A3.
Yeah,
A3, right?
A3.
So now your written submissions are on
Your lordship's written submission, last time you were using a A3.
A3.
A3, right?
There is. So, well, I'll just about 7-8 points. They'll include my written submission, but I just want to make a point. Unless one aspect which your lordship has heard in a somewhat diffuse manner, I want to itemize it. The question is, would my lords Malus not want to prevent such consequences by dealing with the law and laying down the law here? That's the proposition. What are those 5 Malus four deleterious consequences for constitutional law, for constitutional morality, for the whole system, the entire edifice, which is an interlocking system of defections, speaker, legislative wing, governance. They're all ultimately interlinked into one scheme. So my submission is these 4 or 5 deleterious consequences should impel your lordships to decide it here. What are those? Number 1, can you disable the speaker so easily, thereby sounding the death knell of 10th schedule? My lord has heard it fully. Navam Revia is the main standing obstacle, and we have argued on that. That's consequence number 1. Second, is the positive and the negative injunction. I'm just tying up the ends together into a list, which are against Quixote. It is not only the practical effect of this positive and negative injunction, but it is juristically against Quixote.
Suno.
Hearing. I am a veteran of this. Your lordship may consider keeping a raised platform.
That is what
On which this is too little. This should be raised.
But then I thought, I can't see the lawyers as well.
That's a small price to pay for what your lordship will gain. And your lordship may be missing nothing much. Because this flat raising, I keep a flat raising on that, it helps a lot, because otherwise your lordship is bending down.
And you have to, otherwise you have to keep yours back straight.
And you have to bend down in any case if it's not raised.
No, raising means half of you are vanished from my screen. That's the problem.
I think all of us, but on that side of this, we have these postural issues.
This is an occupational hazard. The old vintage. Well, so the second part is, well, the positive and negative injunction is not only factually wrong and has caused the change of government. That has caused, well, I made that argument earlier, but it is juristically wrong. That's the second consequence your lordships should rectify. Only Supreme Court can do these rectifications. Nobody else can. Well, it's really futile to have a whole ladder again starting some high court, the ladder going all the way to Supreme Court. It really is futile. Well, nobody can touch. These are Quixote, these are Navam Rabias. Therefore, well, third is the consequence of the governor's direction for a floor test. Well, there is no way in which the governor can interfere like this, especially in a case where disqualification is sub judice or pending.
The consequence of the governor's direction for a floor test.
Floor test in a pending disqualification matter. Sub judice at two levels, brother. Sub judice at your lordship's level, sub judice at the speaker's level. It's a double sub judice. He's after all deciding in a quasi-judicial capacity there. As a tribunal.
Sure. Okay.
There is this third point, sorry. This third aspect can be rephrased juristically in a different way. Whereas your lordship is dealing with a legislative issue primarily. Executive has no role to come into it. Laterally, sideways, the executive can't enter it. The governor is, though a constitutional post holder, an executive appointee. So this third aspect is really the executive direct lateral entry into a no-go area. Totally impermissible. That's a consequence a lordship alone can rectify, should rectify. That applies to all these consequences. Somebody else will decide. It will be a partial decision. Supreme Court for the polity, for constitutional morality, for the whole system must decide.
This is part of your third point only.
This is under consequences, C. First point is consequence, ABC. This is the third one. The fourth one is, Billups, it is distinct, but it relates to the governor. The governor recognizes a split. Well, if your lordships can't do it, governor will do it. The Supreme Court with 142 today, if a judgment is passed under 141, 142 saying we recognize a split, your lordship would be acting contrary to law. The governor can do it. Directly recognizes in writing a split with great respect. Here there is inbuilt double whammy. The governor is an error as a constitutional holder, and the executive is coming into and recognizing. The central government executive is coming in and recognizing a split. Now that letter, your lordships may not have seen for some time now, maybe in the beginning it was shown. Just turn to that letter, for a minute. Para 7 of the PDF, compilation 2, 326, correct? PDF 326, compilation 2, dated 28th June 2022. This is very important. A constitutional amendment promoting the constituent parliamentary intent to do away with split is collaterally recognized by an executive appointee governor who has no locus, which the Supreme Court can't also do.
Compilation of, there are
CC2,
CC.
of
There is a number for each document.
CC2 it is called, right? CC2 of the document, not the case law.
Okay.
326, convenience
CC.
2.
326.
326 is the PDF page. It's the governor's name on 28th of June.
Nice.
In that volume, it is serial number 5. In that volume.
The volume is called CC.
Oh, I see. The volume is called serial number 5. My apologies. Whereas your lordship, it just takes.
P4. Annexure P4.
No, what is it?
Yes, sir. We got it.
I see. My lord doesn't have it, perhaps.
Convenience.
My ladyship has got it.
Yes, please.
Dear Shri Udhavji, the governor writes to the chief minister. I am going to emphasize para 7, but I'll read 2 and 3 also, leading up to 7. It's para 7 I want to read, but I'll just read 2 and 3 for backdrop. I am in receipt of a resolution dated 21/6, signed by 34 members of Shiv Sena legislature party, stating that there is enormous discontent within the Shiv Sena cadre and the electorate on account of alliance with NCP and INC. The resolution clearly indicates that the majority members of Shiv Sena legislature party want to exit the alliance with NCP and INC, and to that end, they have reaffirmed the appointment of the leader of the Shiv Sena legislative party. I am also in receipt of a letter of 21 June addressed by Mr. Shinde to the Deputy Speaker, stating that the purported appointment of one Ajay Chaudhary is illegal, having been made by 16 MLAs without notice, without quorum, therefore the same is inoperative. So this the governor is saying, well, as the governor can hardly at all interfere in any of these subjects while disqualification is pending at 2 levels. But that apart, leave 2 and 3. Now come to 7. Well, how can the governor say this? Kindly read 7. Is it possible? Forget the right or wrong. Why should the governor say it? How can he say it constitutionally is my question to myself. It is thus clear that a majority of the Shiv Sena MLAs have given a clear indication on behalf of the Shiv Sena legislative party that they intend to exit from the Maha Vikas Aghadi government, and that you have been made aware of the same, and that you are trying to win over your MLAs and cadre means not democratic. I am therefore confident that you and your government has lost the trust of the House and the government is a minority. I'll just pause and look at let us just forget this case for 2 minutes. Look at the consequences of this letter in the constitutional and the juristic sense. Number 1, it is a certification by an executive nominee that the departing allegedly disqualified members, allegedly by me, are kosher. They are not disqualified. They are not disqualified is his confidence. Number 2, that you, Mr. Udhav, is not the Shiva Sena, but those people are. He is writing to Uddhav Thackeray. 3, he is doing it under the nose of a pending disqualification, then scheduled proceeding and a hotly contested Supreme Court matter. The ordinary mortals who are doing it, the Lordship take a very serious view. I know the Lordships can't issue directions to the governor and content may not lie. But just consider, Manoj, if anybody else would write a letter like this, when your Lordship is hearing such a heavily contested matter and the Speaker is dealing with it, I don't know, Manoj, normally, Manoj, we'd expect some contempt notice. Then some appropriate case will also examine how far the arc of immunity applies. Number 4, he is, Manoj, actually setting up the ground as a precursor. Come to me, I will swear you in. This is an advance intimation. This 7th para read as it is can only say, come to me, I am ready to swear you in. Because you are kosher. There is no problem with you, there is no stigma. Only step left is that nothing is left. Therefore, my lords, to the other question, my lord, the Honorable Chief Justice asked me on Thursday, my lords, what is it that you want us to do in the event that we agree with you? Your Lordship put a question like that. One of the simplest levels, of course, I gave Your Lordship a larger answer, simplest level is to quash this letter. Now, suppose Your Lordship quashes this letter, just for a minute. And I do not press, except for one or two things, in any meaningful way for other things. Just suppose, I'm just not conceding anything, I'm just giving Your Lordship a supposition. The status quo ante is automatically restored. Lordship doesn't have to say it. And is that constitutional morality? Is that fair play? Is that upholding the greatest traditions of governance? Because clearly it is. And certainly, there can be no bar, immunity, hesitation, legal obstacle, constitutional bar from quashing this letter if Your Lordship otherwise agrees with me. This letter is not a non-quashable document, Malus.
It's directly impugned.
It's a direct prayer, directly impugned in all the writ petitions or many of the writ petitions. Take it, Malus. Take it that it's impugned. I don't know if you should take out the prayer. No, not from here. So, now, Malus, this is the fourth consequence. The fifth is a obvious consequence of this consequence. Next step is swearing in, which happens on
30th.
30th. This is 28th, 30th. In fact, the seeds of that are very clear in para 7. I told you it's an advance intimation. It happens 2 days later. So that's a letter saying you are kosher. That is what is acting on the letter and giving you a constitutional status of a minister. Well, in fact, I'm sorry, that swearing in was the chief minister. 30th was the swearing of Mr. Shinde.
Chief Minister.
38th.
So you are swearing in a constitutional head of state. And what is the last consequence is again consequential to the consequence, which is appointment of the speaker. If I may say the new speaker or the speaker.
Thank you.
I have given a lordship 6 consequences. I mean, one can make probably 7 or 8 also, but let's say 6. Well, as my respectful submission is, A, that these are serious consequences, extremely serious for our constitutional polity. B, they are case neutral to the present case. They are extremely serious for our constitutional polity. B, they are case neutral from this present case. They are juristic questions and they are bound to recur unless your lordship plugs the loophole this way or that way. Third, these are all within your lordship's judicial domain. None of this is a no-go area. Fourth, and this is very important, fourth, only your lordship, I'm not saying your lordships may, I'm saying only your lordships can decide and should decide this. I'm not even making an optional, according to me, this is only the Honorable Supreme Court, which can and should decide it here, not delegate it to any other authority. then this is the main point, probably. And then, of course, it follows that your Lordship would, as an ancillary, because your Lordship passes ancillary.
Anything else now?
Says, it's just 2 minutes more. Well,
And
your
then at
Lordship,
the end, I have one question, but I didn't want to disturb your
no,
Lordship.
I'll just take about 10 minutes more. I'm going to make some. So, your Lordship will therefore restore, in the ancillary sense, the position as on 27th or such date. That is, because ultimately your Lordship's orders are not spurics. They have to have an effect. That effect has to be only that restoration.
To restore position as on
27th August, June. That is, this is 28th, so 27th is 1 day before. Now, Manus, coming back to my note, and I'll be very quick with that's written down. Come to para 12. This is the other facet. Your Lordship stopped at 12:13 last time. Just come to para 12 of my note.
Where you
convenience cost.
A3, the one your Lordship are using. Now, what is the point? And I'll be very quick with this. Purposive interpretation in 10th schedule legislature cases, your Lordship is repeated many times.
which page, Dr. Singh?
Para 12 of my note, page 5. This is that A3 note. Oh, I see. It's page 7. Page 7?
It's 7.
In your Lordship, it's maybe page 7.
Yes.
Now, Malus, purposive interpretation, what was this new fashion of, now it's old, Bennion calls teleological approach.
Yes, got it.
It is further.
Para 12 commences by saying it is further.
Respectfully submitted that the above course, the next line is purposive interpretation.
Project.
Or your Lordship calls it teleological approach. One of the most abstract books, follows that Bennion, very difficult to read. Now let us just see, what is that purposive interpretation? These are the principles. Why does your Lordship talk of the evil of political defections? Next para. Now it will be very brief. Quixote quoted, well known to your Lordships. Quixote in para 4 cites the statement of objects and then says this, I am reading, the evil of political defection has been a matter of national concern, not combated, likely to undermine the very foundations of our democracy and the principles which sustain it. With this object, an assurance was given in the address by the President to Parliament that the government intended to introduce in the current session of Parliament an anti-defection bill. The bill is meant for outgoing defection. Why are Lordship saying all this in Kyoto, which is 20 years ago, 30 years ago? It's 30 years ago. Because this says that when you interpret anything in this area, you must push this sentiment, this object. That's the object of this. Next, Jagjit Singh. Just see this, fellows. Jagjit Singh, all the citations are given. I'll not go to it. I'll just read it from my notes. The validity of the orders by the Speaker under 2.2 disqualifying certain independent MLAs of Haryana 3 days prior to the election for the Rajya Sabha fell for consideration. Lordship knows in the Rajya Sabha the MLAs vote was. This Honourable Court rejected an argument that the Speaker's order had been passed in haste, observing that the disqualified MLAs were interested in prolonging the disqualification proceedings beyond the date of Rajya Sabha. Critically, it was held that an independent MLA cannot be permitted to avoid the consequence of defection merely by not completing the formalities of joining a political party. So this was not, this was only by purposive interpretation. This was extending and stretching, if I may use the cruder word, stretching it, but stretching it for the purpose of promoting this object. Of course, it's an irony. There, you did it to, they said we'll prolong the disqualification so he can't vote. I said he can vote in the Rajya Sabha. Here, it's the same man as Chief Minister. If Jagjit Singh is right, this is a 10 times a for sure case which we are arguing now. That was only a Rajya Sabha election. Now 29 is what the Supreme Court says. It is also essential to bear in mind the objects, underline the word objects, for enacting the defection law, namely to curb the menace for defection. Despite defection, a member cannot be permitted to get away with it without facing the consequences of such defection only because of mere technicalities. The substance and spirit of law is the guiding factor to decide whether an elected member has joined or not joined a political party after his election. It would not be a validity, etc. I'll skip that. Now see Rajendra Rana, Constitution Bench, well-known case. But it was decided on the basis of purposive interpretation. There were gaps. Your Lordship had to fill the gaps. Your Lordship resorted to purposive interpretation. Kindly see that. this Honorable Court rejected an argument of the initial defection by 13. So this is a two-part defection. Initial was 13. Followed by a subsequent claim by 37 MLAs that there was a split in the BSP in terms of para 3 meant that there was no disqualification of the initial 13 MLAs. Now this is the good old days of a split existing. Even then, look at the way Your Lordship interpreted it. Your Lordship had the split existing, but see how you interpreted it. By purposive. The court applied the principle of purposive interpretation to hold the disqualification occurs on the date when the acts attracting disqualification are committed. Therefore, the question of disqualification, whether there had been a split, had to be determined with reference to the initial date, not the subsequent date. Thus, the defense to the plea of disqualification cannot be a subsequent defense and must have arisen at the time when the acts constituting the disqualification were committed. Now, just read two marked portions. I will not read the whole one. If Your Lordship permit me, the first 6 lines of 33 only. It may be that the collective dissent is not intended to be stifled by the enactment of 1022. But at the same time, it is clear that the object, mark the word object, is to discourage defection, which has assumed menacing proportions, undermining the very basis of democracy. Well, the very basis of democracy comes close to basic structure. Democracy has been held to be basic structure already, obviously. Therefore, a purposive interpretation in para 2 in juxtaposition of 3 and 4 is called for. Therefore, then one thing is clear, the defection is the ground for disqualifying a member. He incurs the disqualification if he is voluntarily given a membership of his original political party, meaning that the party on whose ticket he got elected. In the case of defense of a whip, I'll skip that to save time. Come to the next marked portion, next para, the highlighted portion. The fact that a decision in this regard may be taken in the case of voluntary giving up by the speaker at a subsequent point of time cannot and does not postpone the incurring of disqualification by the act of the legislator. Similarly, the fact that the party could condone, could theoretically, there's a para which allows you to condone, the defiance of a whip within 15 days, or that the speaker takes the decision only thereafter, cannot also pitch the time of disqualification as anything other than the point at which the whip is defied. I'm not only arguing relating back, I'm arguing purposive interpretation. Apart from relating back. Relating back is arrived at by adopting purposive interpretation. Therefore, in the background of the object sought to be achieved by the 52nd Amendment and on a true understanding of para 2, with reference to other paras, the position that emerges is that the speaker has to decide the question of disqualification with reference to the date on which a member voluntarily gives up his membership or defies the whip. That is arrived at by purposive interpretation, no other way. It is really a decision ex post facto. The fact that in terms of para 6, a decision on the question has to be taken by the speaker or the chairman cannot lead to a conclusion that the question has to be determined only with reference to the date of the decision of the speaker. An interpretation of that nature would leave the disqualification to an indeterminate point of time to the whims of the decision-making authority. Same would defeat the very object of enacting the law. Whereas by disabling notice to a speaker, you will achieve the same. By the governor writing letters, you will achieve the same. All these are nullifying the 10th schedule. That's why purposive interpretation is vital. Your Lordship has separately noted with me paras 12, 52 and 53 of Rana. That is done in the earlier department argue. That's not quoted here. Now, Srimant Balaji Patil, Balasar Patil, in para 89, which is quoted, just come to the boldface alone to save time. So I'm skipping long paras in between. If we hold that the disqualification proceedings would become infructuous upon tendering resignation. Now, this is another technique, because if you are disqualified, then you have to fight an election again to become a minister. Well, if you are disqualified, you must fight an election again to become a minister. So people will just resign and then immediately become a minister. Then you get 6 months to be elected. You can become a minister now and need not be elected for a while. So to get around that, this is Your Lordship's purposive interpretation. If we hold that the disqualification proceedings will become infructuous upon tendering resignation, any member who is on the verge of being disqualified would immediately resign and would escape the sanctions provided under 751, 164 and 361. These are remuneration consequences and also most importantly that you have to, you can be a minister but be elected within 6 months after that. That is not available if you are disqualified. Such an interpretation would therefore not only be against the intent behind the introduction of the 10th schedule, but also defeat the spirit of the 91st Amendment. Then, DTC, an inhibition under the Constitution, this is of course not a defection case, but on the principle of purposive. An inhibition under the Constitution must be interpreted so as to give a wider interpretation to cure the existing evils. Now, this is important, even though it's not highlighted, just read this para, 118. Legislation, both statutory and constitutional, enacted and true from experience of evils, but in general language should not therefore be confined to the form that evil had taken. Time works changes, brings into existence new conditions and purposes and new awarenesses of limitations. Therefore, a principle to be valid must be capable of wider application than the mischief which gave it birth. It was born for reason X. Today, our Lordship will expand it to Y, tomorrow to Z, because we learn from experience, brothers. As they said, brothers, not spirit of law, not logic, but experience. Those famous words of Holmes. This is, therefore, a principle to be valid must be given wider application than mischief it gave it birth. This is particularly true of constitutional constructions. Constitutions are not ephemeral enactments designed to meet passing occasions. These are, to use the words of Chief Justice Marshall, designed to approach immortality as nearly as human institutions can approach it.
Between the two अगर करना है मान लो नहीं और एक सेकंड कह रहे तो
Yes, sir.
The last two lines above para 91 in my note, which is para 16 at the end of. In the application of a constitutional limitation on inhibition, our interpretation cannot be only of what has been, but of what may be. My lord has got that para?
what is here?
Well, within 16, I have quoted judgments. In the quotation, there is a para 91, two lines above 91.
Oh, yes.
Then, Wallace, next 91, I will not read, your lordship has it, one is coming out of your lordship's ears, this judgment, 5 days your lordship heard this. Only one sentence I am emphasizing, which was not relevant for the other case. I mean, I didn't argue it then. This is a quotation, Wallace. Last line of 284. The courts must adopt such an interpretation which glorifies the democratic spirit of the Constitution. I'll skip, Wallace. Whole of 17, I'll skip. 18 is a very important paragraph, but I have in a different way covered it factually. It includes an overlap with the consequences argument. All the facts are itemized there. So I'll skip it to save time. 18. A lot has seen my 18. You should just keep it as a factual summary. Now come to 20. Allowing the disqualification petition to be decided by a person who has been appointed as speaker with the active support of the respondents and who has conducted himself in a biased and malafide manner would result in incentivizing the constitutional sin of defection. That's the phrase I want to comment for Lordship's consideration. Incentivizing the constitutional sin of defection and would be against the spirit and intent behind the 10th schedule. The same would be the teeth of constitutional morality. Thus, the principle of purposive interpretation demands that the present speaker not be entrusted. This fellow ends the purposive part. Then para 22 is an interesting point and not merger. Just see the irony here. Your lordships has only one defense, fellows, apart from condonation of merger. Merger is the supreme irony in this case. Merger is not even alleged by them, claimed by them, raised by them. In case of a merger, suppose 8 out of 10, 6 out of 10, 9 out of 10 leave, the remaining chap left behind is protected. Under your lordship, 10th schedule is protected. He otherwise he's a loner. He would himself be he's protected. Here, but for lordship's interim order, which we argued just a few days ago, I'm not protected. Without claiming merger, I mean, today they are issuing letters and whips, which I'm not talking about lordship's protection. The whip is being issued as we speak, in various matters, they are entitled to, if the EC has recognized them. But for lordship's protection, I would be liable to be disqualified for not following his whip. Because without invoking merger, without getting a merger, there is no protection. They become the party. These are consequences. This is a consequence Lordship I add in my 6 consequences. This is a very weird consequence. It's a very weird consequence. If you have the defense of a constitution, you are worse off. If you don't take the defense of the constitution, you are better off. I should have mentioned in the consequences list, Lordship will consider putting it there. It's an absolutely absurd, weird consequence. Then, Manas, I have extracted para 4 in para 23, that is para 4 of the 10 schedule. And I've made this point in para 24 again. And therefore, Manas, I have ended with this. I'm ending my submissions with one, Manas, judgment which I have decided. That's an absolute end, Manas. That's an interesting judgment on, Manas. Where is it found? Where is it found?
3F.
Compilation of judgments,
3F.
volume
3F.
3F. It's a judgment called Indore Development Authority 2028 SCC 129. Constitution bench.
On restitution. On restitution.
Yes. Your Lordship is a party to it.
Restitution, no?
Restitution. Because that's the fifth facet or sixth facet of setting right a wrong. Well, you call it actus curiae, your Lordship will not allow your Lordship's acts or judgments to harm a party. Your Lordship calls it a situation created by your Lordship's order, etc. Another facet of saying the same thing is restitution. And my Lord is absolutely right.
Which page you want to read?
This is in this volume 3F at PDF page
1 minute.
33.
1 minute.
Starts with
33 is the PDF page of volume 3F. And the citation of Indore development is 2020 8 SCC 129.
33.
33.
Para?
So the first para I wish to read is far away in the beginning. It's para 335 at page.
Oh, 335.
Yes, 335.
At page?
At page
275.
PDF page 275. Mark it now. May I read it, brothers? The page of the PDF is 275.
Yes.
My lords have got it. The principle of restitution is founded on the ideal of doing complete justice at the end of the litigation. I emphasize the word complete justice and I emphasize the word restitution. And parties have to be placed in the same position but for, I said the but for test, but for the litigation and the interim order. These are very, very important words on the Constitution bench. But for, that's the test. But for the litigation and interim order, if any, passed in the matter. In southeastern coalfields, it was held that no party could take advantage of litigation. It has to disgorge the advantage gained due to delay in case the list is lost. The interim order passed by the court merges into a final decision. The validity of an interim order passed in favor of a party stands reversed in the event of a final order going against the party successful at the interim stage. Section 144 of the CPC is not the fountain source of restitution. It is rather a statutory recognition of the rule of justice, equity, and fair play. The court has inherent jurisdiction to order restitution so as to do complete justice. This is also on the principle that a wrongdoer should not be perpetuated. Wrong order, not wrongdoer, wrong order should not be perpetuated by keeping it alive and respecting it. In exercise of such power, the courts have applied the principle of restitution to myriad situations not falling within the terms of 144. What attracts applicability of restitution is not the act of the court being wrongful or mistake. So this is apart from actus curiae or an error committed by the court. The test is whether on account of an act of the party persuading the court to pass an order held at the end is not sustainable, resulting in one party gaining an advantage which it would not have otherwise earned, or the other party having suffered an impoverishment. It's very well put for us. I would commend each word of this. Litigation cannot be permitted to be a productive industry. That is only a fond hope. It is a productive industry. Litigation cannot be reduced to gaming, where there is an element of chance in every case. If the concept of restitution is excluded from application to interim orders, then the litigant would stand to gain by swallowing the benefits yielding out of the interim order. Then they quote, I will not read the quotation. Just pause here for 5 seconds, fellows. I get an interim order. The interim order is obviously not confirmed. If the interim order is confirmed, the matter doesn't arise. It is other way around. But every consequence of the interim order is enjoyed, gorged, eaten, and then you twiddle your thumbs and say, tough luck. Now the final order has come too late. You can't ask for restitution. That is what your lordship seek to address by this passage. It's rather well put. For saving of time, I'm not reading. I would request my lords to read Eastern Coalfields, from where it draws strength. It's a constitution bench. And this is the essence of justice. It's the essence of justice. In a constitutional matter with such grave consequences, it is even A for sure. I'm very deeply obliged.
Just one question I had. I mean, it's a facts part. You said, and both Mr. Sibal also said the same thing, that this is not a case where a trust vote is called when the House is constituted for the first time. Whether the governor's powers, of course, the governor has the power to call for a trust vote when there is no clear majority on the floor.
But not after the election that you have for the first
time. It's not after the election because here the government is formed. Very valid point that, this is post-formation of government. What is the power of the governor to call for a trust vote post-formation of the government? What are the circumstances in which he can?
That means a running government.
A running government.
Correct. Well, let me answer on first principle. That of course, we can add some material and give your lordships specifically and note only on this. But on first principles, the first answer is that zero, where your lordship will decide abstract. Zero, answer to lordship, direct question, direct answer. Zero power, where there are pending disqualification issues in a running government. Because lordship should not mix up the two. One is a normal vanilla running government with no issue of disqualification. One is a disqualification pending at two levels. My candid, clear answer to your lordship's direct question is zero. Number two, the reason is what I have given It is a lateral entry of the executive in an area where there cannot be any jurisdiction. There is no locus in either 10th schedule or lordship jurisdiction. Number three, if your lordship's question is premised, has to be premised and rightly premised on the assumption that the governor, what he does in the question posed by the Honorable Chief Justice, what is he doing, He is recognizing ABC as the inverted commas majority. There is no relevance to your lordship's query unless the governor does that. Otherwise, your lordship's query would not be relevant. Obviously, it presupposes that he is giving some imparting legitimacy, recognition, or some status. How is that possible?
There's only one gray.
In constitutional law, it's not possible.
Not so much from the facts of this case, but we're looking at now the
Yes.
perspective. On the facts,
I tell lordship,
when you read that letter of the 28th of June 2022, the governor, you said that what the governor essentially did was to recognize a split by the letter. In fact, that letter does say that so many people have left you, and therefore, there
without using the word split, is a full recognition, my submission to the lordship.
de facto recognition of a split.
Yes.
Correct. Now, your answer to that is that the governor, so long as the disqualification petitions are pending, he cannot call for a trust vote for the simple reason that you are still a part then of the government which is supported when the House was formed.
Except in one case,
Right.
where for some freak reason which I cannot think of, it will never happen, that nobody decides to seek to disqualify the other. Now, suppose
Often the speaker, what he may do is that
no,
I don't disqualify you at all.
no, that is not so
Then
simple.
you contribute to the majority of the
No, I am doing a juristic answer to your lordship's query. It can never arise in practice, but I am giving a juristic answer. That will have to be a situation where there is no cavil and dispute. I mean, it is virtually by consent of everybody. But with that answer comes a caveat. It goes back to the origin and the object of the 10th schedule. Why was it enacted? It was enacted not to encourage these trust vote situations by defections. Unless that is so, it will rise every week, every 2 weeks.
One of the last point, maybe you can take 2 minutes to put this to the other side also.
Yes.
It's a worrying issue. There's no clear answer.
No, I'm very grateful because it helps us to clarify in our own minds also. Just to clarify now.
There is in assessing the strength of a ruling party in the House, whether it's the Legislative Assembly or the Parliament, you have a numerator and you have a denominator. The numerator represents the strength of the party when the house was formed. The denominator represents the total strength of the house. Now, by calling for a trust vote on 28th of June 2022, the governor, according to you, your argument is that the governor therefore recognizes that a part of the numerator has evaporated or has been taken away.
It's rather nice we're putting in numerator.
The numerator has been taken away. And therefore now I feel you have lost the confidence in the house. According to you, that is not permissible because the disqualification petitions are still pending.
And he recognizes and gives legitimacy to the numerator. In your lordship example, he is recognizing and giving legitimacy to the numerator.
The only problem which I think, which is kind of not, which is worrying is, does the governor not also recognize that the very act by which the numerator may or may not be affected? All right. For instance, the numerator would be affected even if you don't treat it as a split, and this is a clear disqualification. Then the numerator is reduced by X, the strength of the ruling party in the house, minus Y, the people who have defected from, who have therefore attained disqualification. But equally, that same act affects the denominator also.
Because it reduces the total strength.
The total strength of the house.
Correct?
So, though the governor cannot therefore say, the governor cannot legitimately say that, look, these people have left you, therefore I want to trust.
Correct?
But can the governor not then say that, look, assuming that there is no recognizable concept of a split now under the 10th schedule, the effect of all this is that these people have to be reduced both from the numerator and the denominator.
Straight away. There are many answers. First, this exercise cannot be done by the governor because there is no mechanism for it generally.
You have been arguing that he can't assume to himself to take a decision.
First, you have Lordship 3 or 4 answers. Lordship, note down my very specific answers. This is an exercise itself which he cannot embark upon. The governor has no such jurisdiction to embark upon when there is a running house. Now, second answer.
Right. He can't embark. But can you not, therefore, they then say, I want this exercise to be demonstrated on the floor?
No, I'm saying that exercise you can't embark. Let me answer.
Can you not?
He
has argued that.
Second answer.
Argued that he won't have the. It has to be.
Whereas numerator denominator, you can't start because your lordship has to premise a direction by me to him. I'm the governor, I'm giving him a direction.
So in other words,
please have the
argument.
You can't give a direction.
Got your point. Therefore,
the legislature, the speaker or the chief minister can say, sorry, I don't obey this direction. I don't hear this.
Your argument, therefore, until the outcome of the disqualification petitions is known to the governor,
exactly,
he cannot then call for a possibly using your line of argument. We're just trying to understand the argument and stretch it to its conclusion. After the disqualification petitions are decided by the speaker, then there is clarity in the mind of the governor on what is the extent of the numerator which has been affected.
I am very grateful. I was going to answer, I am not conceding, but I was going to answer because that question will arise. You also will be very careful about a hypothetical situation, but possibly were. But why is that? Because a constitutional designated judicial or quasi-judicial tribunal has given a verdict. After that, there is something, as the Lordship puts it, that verdict, unless disturbed by the High Court or Supreme Court, is binding or operating. But here, your Lordship's query answers the first part. You are doing it well before.
You say another point in your favor, actually, which is that the very same unit which affects the numerator affects the denominator also.
Yes,
right. So, if the governor cannot postulate until the disqualification petitions have ended that the numerator has been affected, then he cannot say that the denominator is affected.
No, he cannot. By the very arithmetic, it has to be both. It is very selective otherwise.
Right. Because the same act of defection which reduces the strength of the ruling party, which also then affects the strength of the house.
And Manus, can you start doing this? This is the word premature stares your lordship in the face. Constitution says this body will decide. This body is yet to decide. You are going to give a decision virtually. I will reduce the denominator, I will reduce the numerator. That will create chaos. And Malus, your lordship has to see Malus
You are saying
so
you can't take cognizance of the existence of the 10th schedule proceedings. He can take only upon an order passed.
Consequence of the 10th schedule proceedings.
After a determination by the 10th schedule.
That's a very pithy summary. the consequence of the 10th schedule can be some basis, unless disturbed by the High Court or Supreme Court, to act.
Until then, they continue to be members of the.
And it would be in rem. Once that
Otherwise, this would be really a method.
There'll be chaos. There'll be chaos. And unless, not that it should come into your lordship cannot ignore the reality of around the country. Governors also.
We got your
Governors are no more angels.